Tourism Holding Company against the Ministry of Religious Affairs, Government of Pakistan.
Yes, Ms. Halbron.
May it please your lordships, I appear for the appellant, Dallah Real Estate and Tourism Holding Company, with my learned friend Klaus Reichardt, Mr. Toby Landau and Mr. Patrick Ingenue appear for the Government of Pakistan. My lords, as you will have seen from our case, this appeal raises issues which go to the very heart of the effectiveness of the New York Convention. The increasing use of international arbitration as an attractive alternative method of dispute resolution compared to litigation emanates in large measure from the success of the New York Convention 1958. It has been described as one of the most successful international conventions ever promulgated, and it now has 144 signatories. The facility with which awards under the New York Convention can be enforced.
Can you just stop for a moment, because I seem to be missing a substantial part of my papers. I'm not quite sure what's happened. Your written case and various other things. There's so many bundles. I'm very sorry to interrupt you, but I really want to be quite sure I've got this.
Many bundles.
It's not these. No, it's not the authorities. It's the written cases.
I think it might be those.
Well, they went on to your side.
Yes.
Right, you see what I found them. Thank you very much.
I was commenting on the facility with which awards can be enforced under the New York Convention is the key to such success, trumping the often more difficult process of enforcement of judgments internationally. And as your lordships will have seen, this is the second reported case since England incorporated the New York Convention in the 1975 Act, where an English court has refused to enforce a New York Convention award under Article 5.1 of the Convention. The case has huge international implications, as it signals whether the practice of the English courts in relation to enforcement matches its stated pro-enforcement stance. The Court of Appeal decision and the decision below have attracted considerable interest and criticism from around the world. The English attitude to arbitration was, until the 1996 Act, somewhat out of line with other countries. That Act was a major shift towards harmonisation of arbitral procedures and a less intrusive role for the courts, though it did not adopt the model law in every respect. Today we are considering only part of that Act, namely those sections which incorporated the New York Convention. I find myself in this appeal in a somewhat unusual position, in that if I look ahead to Lord Savile in front of me, I see the author of the Act, and if I look to my left to Mr. Landau, I see a drafter. So I hope that those gentlemen knowing far more about the etiology of the Act than I do will bear with me as I proceed to analyse.
I don't think you ought to make that assumption in my case, because for some years I've been engaged on something completely different.
Indeed, my lord. But in any event, I hope you will bear with me as I go through the relevant parts of the Act.
But in the end of the day, we take the language of the Act.
Indeed, as I was going to...
And that's what it really comes to.
Indeed.
You mentioned there had been a lot of international writing. Are you able to just give us the tab numbers in the authorities' bundles, or don't we have that?
Well, the international writing about the case... there was one we put in the case itself, the blog, yes. But it's more commentary from feedback from people one talks to in the international world than specific articles. They have, my learned junior has another article which we haven't put in the bundle, but there are articles which have
what is that?
That is the Paris Journal of International Arbitration.
And it's been referred to in a very recent book on the Arbitration of Scotland Act, which yes. Is not precisely the same, but in a book that's just been published, the case is referred to both before Mr. Justice Aikens and the Court of Appeal.
It is referred to quite frequently, and it's obviously been referred to in other cases
yes.
in other countries.
Who's the author of the Paris Journal?
It is...
It's the new journal. It's the new Paris Journal.
It's the new Paris Journal. The editors are Charles Kaplan and Alex.
No, the author of the article.
There are two articles in it.
We're going to get copies of those, aren't we?
We can provide you with copies, yes.
Yeah.
But I was only making the point at the outset, not that I would necessarily adopt their criticisms in whole or in part, and some of it I will, but simply to indicate the importance of the case, not just, as so many cases before your lordship, which has national implications, but this has a much wider implication. That was the only point I was making at this stage. My lord, as your lordship knows, but just for the benefit perhaps of those behind us, the case concerns enforcement of a unanimous ICC arbitration award rendered in Paris by an eminent international tribunal comprising Lord Michael Mustel, Dr. Nazim Hazem Shah, former Chief Justice of Pakistan, and Dr. Ghalib Mahmasani, who's a Lebanese lawyer, who was the chair. In 1995, Dallah, my clients, proposed to the government of Pakistan the idea of providing housing in Mecca for pilgrims performing Hajj. This, in due course, led to a memorandum of understanding on the 24th of July 1995, made between Dallah and the government, and later on the 10th of September 1996 to the agreement, the subject matter of this appeal. The agreement was on its face stated to be made between Dallah and the Trust, a state entity. The respondent, the government of Pakistan, was not a signatory to the agreement, nor was it named as a party. Had it been, we would not be here today. The first issue before the tribunal and the focus of the English proceedings concerned whether or not the government was a party to the arbitration clause in that agreement. The tribunal found on the law and the facts that it was. It subsequently found the government to be a party to the underlying agreement and in Dallah's favour on liability, and awarded it $18,907,000 odd dollars in damages together with costs. The government did not waive jurisdiction before the arbitral tribunal and has asserted sovereign immunity. If, however, it is found to be a party to the arbitration agreement, it is deemed by virtue of Section 9 of the State Immunity Act 1978 to have waived its immunity in relation to the arbitration proceedings. That is different from enforcement against assets.
Yes.
Dallah obtained leave to enforce the award as a judgment of the English court. This was challenged by the government under Section 103(2)b of the 1996 Act, the basis of the challenge being that it is not valid under the law to which the parties subjected it, or failing any indication thereon, under the law of the country where the award was made.
And it's the latter part.
And it's the latter because the agreement did not have any choice of law clause. Mr. Justice Akins, as he then was, after a full rehearing, set aside the leave to enforce the award given by Mr. Justice Clark, coming to a different conclusion on the facts, applying French law to that of the tribunal, and his decision was upheld by the Court of Appeal. My Lord, with that very brief introduction, I would now like, if I may, to turn to the facts. My Lord, given that some 80 pages...
We've got quite a complete account of it in your written case, which we've all been able to read.
Well, what I would like to do, my Lord, with the greatest respect, is my learned friend has spent some 80 pages, including appendices, on the facts.
Yeah.
Obviously, the underlying facts are of importance, and it's, for example, not easy for your lordships to understand it if, for example, you're not taken to the full agreement. So what I would like to do is to take you as briefly as I can through the facts, because they are critical to the underlying submissions that we're going to make. And one can't make the submissions in a vacuum without you actually having seen them. And just reading them, although you've seen the agreed statement of facts, and you've seen the two slants, in my submission it will be easier for you if you just see some of the documents. I'm conscious that it's, in one sense, a tedious process, but in my submission it's an essential process.
Well, if you could use your case as a sort of template, as it were, and...
I will. I'm basically, in my submissions, if it's any assistance to your lordship, will be going through it in the order of my case, though not verbatim to the case, obviously because I will be taking account of points made against me in my in Mr. Landau's.
Yes.
What is the basic message or theme which you're going to ask us to be considering when we're looking at the facts? Is it that the courts below were just dead wrong to disagree with the arbitrators, or what? In other words, is that the purpose of the review of the facts, or what is the purpose?
Well, I think there are several purposes. First of all, both the tribunal and the court considered the test of common intention. I'll come in a moment to the difference between transnational law and French law, which is an issue I have to deal with. But when you are looking at the common intention, one has to take away one's natural instinct as an English lawyer, and one looks at the test of the intention of the parties from the beginning to the end, looking at their behaviour objectively to determine the subjective intention. And the purpose of taking you through it is to indicate, first, that the tribunal got it right, but if I'm wrong in that, to show that there were that it was not, this was a case where it was possible to give different interpretations, but primarily that when you are looking at the award, as we will do, and I will be asking you to place emphasis on that, that inherently the tribunal got it right, and therefore when you're looking at reviewing an award, when you have a fully reasoned award which on its face stands up, considerable weight ought to be given to that, and the English court should not be trying to reinterpret documents where there's no new evidence.
And can I take it that you'll be going and answering the various points that Mr. Landau has as to why he says the tribunal got it wrong? He's got the list.
Indeed.
You'll deal with that.
I will do my best. So, my Lord, before I do that, though, I would just like to reiterate briefly the French test, which I said in a sentence a moment ago. For your note, the summary of French law is set out in paragraph 49 of our case, at pages 20, and starts at paragraph 49, pages 22 to 25, and a more detailed exposition is at paragraphs 85 to 96 of Mr. Justice Aiken's judgment. But if I can just paraphrase it, and I hope there is little between us on this. Essentially, in order to determine whether an arbitration clause upon which the jurisdiction of an arbitral tribunal is founded extends to a person or party who is neither a named party nor a signatory to the underlying agreement containing that clause, it's necessary to ascertain whether all the parties to the arbitration proceedings had the common intention, whether express or implied, to be bound by the agreement and hence the arbitration agreement. Or to put it another way, that the non-signatory was aware of the arbitration clause and accepted its terms. Under French law, this common intention is determined in the light of the facts of the case, starting at the beginning of the chronology and going on to the end, looking at the facts in the round, including considering the involvement and behaviour of all the parties during the negotiation, performance, and, if applicable, termination of the underlying agreement. And the court seeks to ascertain the subjective intention of the parties through their objective conduct. In other words, if you behave as a party, that is an objective piece of conduct that can be deemed to indicate that you intended to be a party.
I mean, both parties have to
yes, indeed.
satisfy the intention.
Indeed, indeed.
Is it suggested that transnational law leads to any different conclusion?
We say no, but points are taken on it by my learned friend as to whether or not it makes a difference, and I'm going to come to that and explain in our submission it doesn't.
At what date are you looking at intention?
Well, you're looking at intention under French law at the whole period. You're not looking at it at a particular date.
No. Does that mean you've got to have the intention throughout the whole period of the contract? Or
no.
What if you came to the conclusion that there was never any intention to be party to the contract throughout its course, but that a subsequent date a party had indicated or said something which, on the face of it, indicated a belief that they were a party to the agreement?
That is highly relevant under French law, and that would be sufficient in our submission.
Without any, although the contracts pass, then, and there's no reliance on that, and no detriment, no consideration, no cause.
You have to look at it in our submission in one of two ways. You can either look at it as to the involvement of the government throughout, but if you were nonetheless to take the view that the government had not expressed an intention early on, but later expressed an intention, for example, in the process of the termination, to become a party, that in our submission under French law is sufficient.
Without any sort of reliance or cause or quid pro quo or anything of that nature.
It's a question of what the parties... If by the government's behaviour it indicated that it intended to become a party to that agreement, that under French law in our submission is sufficient. There was some cross-examination at the hearing because our expert witness indicated that there was perhaps something, a slightly different format of French law called adhesion. But under cross-examination, he accepted that the test throughout was the question of common intention. And the only difference would be as to when that party intended to become a party. So
both parties have to intend it at the same moment, do they?
Well, I'm not sure both parties necessarily have to intend it at the same moment.
I mean, if A intends it up to date A, and then no longer intends it, and B intends it between date A and date B, but A never intends it between date A and date B, that'd be no good, would it?
I think in that situation, but in our submission, our clients intended it throughout, and we will point you to the evidence. And it is our submission that the government was involved throughout. But even if we're wrong
Being
on
involved is not quite the same thing, is it?
Yeah, well, the government were involved and intended to be a party throughout. But even if we're wrong on that, and you will see both the tribunal and the courts, or Mr. Justice Aikins, the most critical thing, as I'm sure you've read in the case, was what happened at and around the end of the performance period, because this contract was only in existence for 3 months. And therefore, how it ended, who ended it, and who intended to be a part at that point is quite critical. So, but just to emphasise, it is sufficient for my purposes for the tribunal to find that it was at the end only that the government became a party. And what you will see when we go through it, when we go through the award and the judgment, is that to an extent both the court and the tribunal were of the view that although there were factors early on, it was what happened around the time of the refusal to re-promulgate the ordinance, which effectively meant that the trust, to quote the learned judge, went up in a puff of smoke, happened, which was critical to both decisions.
The judge made it clear, I think, in paragraph 105, for example, that he was going through the chronology from beginning to end.
Yes.
And that's what he said. That's the task he set himself.
Yes.
Are you saying he didn't actually carry it through to the end?
My lord, I don't think there's any dispute that the judge applied applied the right test in the sense that he used the right test. It was his application of the facts to using the French test, which is the difference between the way the tribunal did it and the way he did it. I'm not criticising his formulation of the French law, but what I am saying is that applying French law, the test of common intention, which, as Lord Collins says, is the same in transnational law, the test of common intention, both in effect applied the same test, but when looking at the facts of the case, the judge took a different view, largely on one letter from the tribunal. And what we say is in those circumstances where there's no new evidence, one has to look very carefully as to whether an English court is right in coming in and completely effectively ignoring, although I mean, he obviously read the tribunal's decision, but coming to a different conclusion on the facts of that case.
I mean, on this part of the case, it's just a question of facts. It's got nothing to do with the future or international arbitration at all. It's just a question of how you apply the agreed principles of French law to the facts, isn't it?
Well, it has more with respect, Lord Clerk, because...
So we're just regurgitating the same old cases the third time round at least.
Well,
must be the fourth time round if you count the tribunal.
I have to do it for two reasons. One, my learned friend has spent so much time in his case, only in fairness to my clients, I must, with respect, deal with it. But secondly, It is relevant because it's relevant when you are considering, when we get to the first main issue, which is the extent of the review. One of the considerations that the court will have is what is the weight that should be given to the award. And you can only understand the weight to be given to that award when you see the award, having seen the facts on which it was
the answer is appropriate weight depending upon the circumstances.
Well,
Can I just put one point on
yes,
the award,
Your
because it goes to your the point we've just been discussing about when the intention is relevant. It seemed to me, reading the award, and that it was actually decided on the basis that the inquiry was as to the intention throughout. The award says such behaviour shows and proves the defendant has always been and considered itself to be a true party to the agreement. And it said the defendant has been in actual fact the party that was involved in the negotiation, implementation and termination of the agreement with the claimant from the first day that the housing project was contemplated until after the repudiation of such agreement. This was and remained true before, during and after the existence of the trust. So their conclusion was based on an overall assessment of, if you like, common intention. That's paragraph 12.2 on page 422.
yes, and if you go on just to paragraph 13, of course, they do say certainly many of the factors of the above-mentioned factual elements, if isolated and taken into a fragmented way, may not be construed as sufficiently conclusive.
It was, I thought it was the joint opinion of the French experts that you do look from the beginning to the end.
Indeed, yes. But they were cross-examined as well, and because there was live testimony from both French experts. There wasn't a great deal between them in the end, but there were one or two issues. So for
Anyway,
these,
you were going to go into the facts, and
if I may.
so we can look at that.
My Lord, as I explained in the case, it was what I will do in order to endeavour not to burden you with too many documents. I will simply state the facts, some of which I think are non-contentious. Insofar as I want you to look at a particular document, I will ask you to do so. What I might do just at this stage is ask you kindly to take up bundles C and D. C are the documents, and D10 is a statement of Mr. Nakvi, who is a director of Samaha Holdings, and effectively negotiated on behalf of the appellants.
So can we put away for the time being A and B?
Yes,
Just to
all you
clear the
need, I
decks
think,
a bit.
for the moment is C and D.
Yes.
This was a high-level government project, and it involved not only senior members of the government, but involved meetings with the Prime Minister. Dallah is a part of the Dallah Group, and it's been involved in the promotion of holy places in Saudi Arabia for over 80 years, providing services for pilgrims visiting Mecca, and is the largest provider of such services in Saudi Arabia. An important piece of background information is that, in the context of what happened here, is that Dallah has for a number of years been one of the largest lenders doing business with the government of Pakistan. It's been an active provider of Islamic finance to the government to the tune of some $365 million in the 5 years before the agreement, and it's therefore established a relationship with members of the government. And the proposal was put forward, and you see that, just for your note, is paragraphs 55 to 58 of Mr. Nakvi's witness statement.
So what page is that?
That's tab 10, bundle
Tab
D.
Under D.
This is all in the agreed statement of facts.
Yes, quite a lot of this is. But I want to emphasise these points because considerable criticism has been made against my clients in that we are a commercial entity, which of course we are. We have come in, we should have known the risk. On the other hand, there can be two ways of looking at this. Here you have a government who has been doing business with my clients for many years, successfully, for which there had been no problems. My clients are entitled to rely upon them, and what happens here is after 3 months they fail to repromulgate the ordinance so that the contract disappears. My clients are left without any remedy because it's accepted that by operation of law there's no remedy against the government. So,
can you just help me? I mean, was there any, as a matter of interest, any evidence about what would have been the position after the trust disappeared if it had any assets? Would there have been any way of enforcing a claim against the trust in that situation?
well,
or against the assets?
I think
was there any evidence?
there wasn't really any evidence. I think what would have happened with the assets is the assets were going to be held through one of my clients' associated companies as the trustee bank. But there weren't any assets, of course, because it was 2 years hence.
No, I'm just...
But from recollection, I'll be corrected if I'm wrong, I think there may have been a little bit of discussion. I think if I recall looking at the transcript over the weekend, there was some discussion about what would have happened. But in practice, nothing did happen, and it really, in a sense, is academic because it had a three-month life. One might be able to argue Lord Mance's point if the promulgation had been much later. But in practice, it was inevitable that there would be no money because the source of the money was to come from the pilgrims, and the pilgrims weren't going to be able to provide any money until there was some housing.
But your problem really is not that the trust ceased to exist. The problem is that it didn't have any assets. Even if it had continued to exist and be re-promulgated and had simply said to you, go away, we're not having any further part in this project, you would have been left with a claim against a shell without any assets.
Well, not with respect, if I'm right.
No, not of course if you're right that the government of Pakistan is behind, but you complained about the government of Pakistan's failure to re-promulgate the trust. That seems to me not the real problem, necessarily.
Well, except if they had not taken away our contractual partner. In other words, it was the government who prevented the contract continuing. If they had not done so, then we would have been able to continue with the contract. And thereby would have, presumably, there would have then been some assets against which to enforce if at a later date there was a breach. But the point I was really making here was that this was, although it was a commercial, there was also an undercurrent to assist the pilgrims. And if you've got Mr. Naqvi's statement, you will see that he deals with the plight of the Pakistan pilgrims in paragraphs 6 and 7. And in summary, he comments that they tend to be poorer and older, have to wait until late in life and suffer great financial hardship making the pilgrimage, often being exploited by unruly Saudi landlords and packed into overpriced accommodation. And at the last sentence, he explains, the last in paragraph 7, as a result, it seemed to me there was potential for a scheme to be introduced in order to provide some form of assistance to the pilgrims from Pakistan. And if you go then to the first document that I will just take you to, which is the very beginning of the history, which is the letter of the 15th of February 1995, which is at page 1.
Of the same bundle?
Of bundle C. And it's useful just to see this, because this is the start of the story. And it's written to His Excellency, the Ministry for Hajj. We're taking the opportunity to write to you about a very special situation that's arisen in Saudi Arabia, which will prove to be an enormous benefit for the government and the people of Pakistan. He then goes on to say the King of Saudi Arabia and the custodian of the holy places has given the task of maintenance to the Dallah al-Baraka group, And due to this, we've been closely involved in the development and expansion of the holy cities. As part of this development, new regulations coming into effect, the group has been allowed to offer to selected Muslim governments housing complexes in Mecca and Medina for 55-year leases. As you may be aware, the government of Pakistan rents housing in Mecca each year for the Hajj, and every year there's a problem. The acquisition of these sites will eliminate this problem for a period of 55 years and would also result in considerable cost saving for the government of Pakistan. And therefore they make the proposal, and in the end, last paragraph, in closing, we'd like to add it's a unique opportunity for Pakistan, and we hope we'll be able to assist more Pakistan Muslims in performing their religious obligations and earn the blessing of God Almighty. And then they ask to make a detailed presentation. So that's how it starts. And without taking you through all the documents, it's quite clear, both from the documentary evidence and from the statement of Mr. Naqvi, that senior members of the government and ministers, as I said, from the Prime Minister downwards, the Ministry of Religious Affairs, the Ministry of Education, the Ministry of Finance, were all involved throughout the whole project. And the government's approval was required at every step of the way, and in relation to every aspect of the deal. Its approval was required in relation to the lease and the financial plan. The Pakistani ambassador viewed the potential for sites in Mecca, and the government had input into the site chosen. The detailed specifications and drawings were approved by the government. And even after the agreement, to which the government was not a signatory, had been signed, Mr. Naqvi explains that all his dealings were with members of the government. Now, the structure of the deal, as evidence by the agreement, arose because it was a means whereby the government could finance the project consistently with Islamic principles. And the ultimate structure was an Islamic finance lease, because, as you know, under Islamic principles, you can't claim interest. And it enabled also the government to obtain dollars outside Pakistan at a time when its currency had devalued by approximately 15%, and there were foreign exchange issues. So that's what underlined it. And the essence of the deal in our submission didn't change. It was simply the manner in which it was to be financed. Mr. Naqvi explains that there were two options. Either the government could divert its own borrowed funds, or Dallah could raise funds by way of a facility backed by a government guarantee. And you see that, for your note, is paragraph 46 of Mr. Naqvi's witness statements. So we now come to the first agreement, which is the Memorandum of Understanding. And that is dated, perhaps before I do that, let me just take you to page 19 as an example of what I was saying, which is a letter of the 15th of July 1995. Financing proposal, Hajj housing. Further to our discussions with the Secretary of Finance, we are pleased to set forth below the terms and conditions for the proposed lease financing for the housing project. Borrower Awami Trust, guarantee government, maturity 13 years. Repayment, the repayment schedule envisaged for the principal and profit is illustrated in Schedule A. Documentation, Islamic lease finance documentation, will be submitted to the government for approval. And then there's details of the financing. And
what I don't understand is why this involved necessarily the introduction of the trust. I mean, the government of Pakistan had its own funds, or presumably it could have borrowed under an Islamic lease itself.
well, as Mr. Naqvi say, there were options. This was a method that was used.
I mean, this is just an alternative.
An alternative, yes.
Yes, I see. So,
And this is what was decided in the structure in the end in this case.
I mean, at this moment, the trust would be the borrower, and the government would be a guarantor. Not a party, but a guarantor.
Can I just take you now to the agreement? Because before I do so, let me just take you to a letter of the 18th of July, page 28. which indicates that the Cabinet had approved in principle in December the proposal for the establishment of the trust. I think that's all you need to know about that at this stage. And it will, over the page, the intention is to establish a separate fund known as the Savings and Investment Fund. We then go to the Memorandum of Agreement, which is referred to, but I think it's easier to read it in full, and that's at page 30. And this is dated the 4th of July 1995. It's made between the President of the Islamic Republic of Pakistan and Dallah. And Clause 1 requires Dallah to acquire within the Holy City lands necessary for the development and construction of the housing facilities sought by the government for Pakistan pilgrims while performing Hajj and Umrah, as more specifically described in the schedule. Clause 2 sets out the cost of the land and the housing facilities to be constructed thereon. Clause 3, upon the completion of the housing facilities, Dallah shall demise and lease them to the government, along with the land, and the government shall take the said facilities and land on such lease for a term of 99 years, subject to Dallah arranging the necessary financing for the government on terms approved by the government in accordance with the provisions of this agreement. And then 4, within 30 days of the execution hereof, Dallah shall prepare and submit to the government for its approval the terms and conditions of the proposed lease and the detailed plan for financing of the same. Approval and acceptance of the lease and the financing plan by the government will be communicated in writing to Dallah. The date of receipt of such approval by Dallah will be the approval date. Where such approval and acceptance is not conveyed by the government within 90 days of submission of terms and conditions of the proposed lease and detailed financing plan by Dallah to the government, or the government conveys its disapproval or non-acceptance of such terms and conditions and financing plan, no liability or claim shall be incurred by either party. 5, the lease financing to be arranged and organised by Dallah as per the approved finance plan will be secured by the borrower designated by the government under the sovereign guarantee of the government. And within 60 days, Dallah shall prepare and submit detailed specifications and drawings of the housing facilities based on the requirements of the government. And within 24 months, from the date that the government approves the specifications and drawings, Dallah shall develop, construct, complete in all respects, and hand over vacant possession of the housing facilities to the government upon execution and registration of the lease. And then if you could jump kindly to clause, I think page 36 is probably enough for present purposes. You will see it's governed by Saudi law, and you will see that there is a provision for arbitration, but it's not the same provision as ultimately ended up in the agreement. It's for arbitration in Jeddah according to Saudi law with 3 arbitrators. And then clause 25, to the extent that the government may be entitled in any jurisdiction to claim for itself immunity in respect of its obligations under this agreement, itself from any proceeding, suit, award, etc., or other legal process, or to the extent in any jurisdiction there may be attributed such immunity, whether or not claimed, and it seems to be that the sentence was not
very easy to construe, is it?
No, but when you look at later on, it seems to have been a typing omission. But it waives any objection to the citing of the venue, and 27, it consents generally in respect of any proceedings arising out of or in connection with this agreement, giving of any relief.
This is supposedly a waiver clause, is it?
Which
Clause
26.
What about 25? Is
Well,
that a waiver
25,
clause
I think is a waiver of immunity clause, but it doesn't complete. When we get to the agreement, you'll see that the full clause looks as if somebody's typing it has not just finished the sentence.
Anyway, in your case, it was supposed to be a waiver clause.
It's supposed to be a waiver clause. And I think the other important clause really is 28 over the page. The government agrees not to assign or transfer its rights and obligations under this agreement without the prior consent in writing of Dallah, provided that nothing herein shall preclude the government from entrusting the buildings constructed by Dallah under this agreement to any other person, persons, company, corporation or trust for its management and maintenance, whether through transfer or lease, to be called the borrower under the financial plan and lease financing referred to in Article 5 of the agreement. And then over the page, at page 38, you will see that it's signed for and on behalf of the President of the Islamic Republic by Mr. Lutfullah, Secretary, who does play a prominent role later in the history. Now,
when was the trust created?
The trust was created in January 1996, and it was announced or gazetted on, I think from memory, the 14th of February 1996.
I thought the ordinance was promulgated on the 31st of January.
We're coming to that in a moment, yes.
And yes, you're quite right. The Court of Appeal say it came into existence on the 14th of February.
And so we really now come actually, I think that is the next document I need to take you to. We can skip all the leases, etc. And the next relevant document, perhaps just passing through, is page 86, because in September, an associate company of the appellant purchased the land and in November transferred it to Dallah. That becomes perhaps relevant later, but the next document is the ordinance, which is at page 93. And that's dated the 31st of January. And the recital, if I may just spend a few moments on this, whereas it's expedient to provide for the establishment of a trust to mobilise savings from the pilgrims desirous of performing Hajj and investment thereof in the Islamic modes of investment, and for facilitating Hajj operations and matters connected therewith and incidental thereto. And whereas the National Assembly is not in session, the President is satisfied that circumstances exist which render it necessary to take immediate action. So you'll see the two purposes are, one, Islamic modes of investment, and secondly, facilitating Hajj. And then over the page, you will see the definitions, and if I can just draw your attention in particular to little e, managing trustee means the Secretary, Religious Affairs Division, Government of Pakistan, or such other person of integrity having a good record, etc., as the federal government may appoint to perform the functions of the managing trustee. Trustee bank means a bank or financial institution appointed by the board to collect deposits from members, maintain their accounts in the fund, and make investment thereof in accordance with the direction of the board. And 3 is important because it appears in the agreement: establishment of the trust. As soon as may be after the commencement of this ordinance, the federal government shall, by notification in the official gazette, establish a trust known as the Awami Hajj Trust. It shall be a body corporate having perpetual succession and a common seal with power to acquire, hold and dispose of property, and may by its name sue and be sued. The headquarters of the trust shall be at Islamabad, and it may establish its regional offices in such other places as the federal government may be determined. And then you see the purposes and objects of the trust is to mobilise the savings and to invest the savings, defray the expenses, and adopt measures for facilitating the performance of Hajj. And then you see the Board of Trustees. Not all, but the majority are members of the government. The chairman of the Pakistan Banking Council, for example, is not, but there are a considerable number. And then at 5.2, which is important, the Secretary, Religious Affairs Division, Government of Pakistan, shall act as Secretary of the Board. That becomes relevant later, so he wears 2 hats once the trust comes into existence. And then you have the powers and the functions, of the managing trustee. I'm not sure much turns on that. At page 9710, the fund of the trust to be known as the Savings and Investment Trust and shall be maintained by the trustee bank. and it should be financed by the following sources: contributions and savings by the members, contributions by philanthropists for the welfare of Hajj, profits earning and capital gains from the investments made out of savings of members, and income from movable and immovable properties of the trust. And then 11 reports: the managing trustee shall, by the end of each financial year, or as when the federal government may direct, submit annual audited report of the fund to the board and such other reports about its activities as the board or the federal government may direct. And then the board may, with the prior approval of the federal government, make rules for carrying out the purpose of this ordinance.
And did it have any life, as it were?
No, it had...
In this document? Was it contemplated how long the trust would last for?
Well, it was stated to be a perpetual body. If you look at 3, the trust should be a body corporate having perpetual succession and a common seal. It had a life... Well, the actual trust lasted from the 14th of February until midnight, or 1 minute past midnight Islamabad time on the 12th of December later that year.
Where is the Pakistan constitution or other provision which says that these ordinances only operate for 4 months?
Well, this was the evidence before the tribunal, and it was accepted by the judge to his somewhat consternation, I think, that it was clearly accepted that it has to be repromulgated. And if it's not repromulgated, it lapses, unless it can be repromulgated retrospectively, but it wasn't in this case. And what happened, quite clearly in our submission, is there was a change of government. There was a change of government on the 6th of November. The next time it was due to be repromulgated was 6 weeks later, and the change of government, because, as you will see as we're going on in the history, they were being pressed to sort out or assist with the sorting out of the financing, and the financing of the project was dependent on the trigger of the government providing a guarantee. The government, for whatever reason, clearly decided this was a project it didn't want to pursue, and therefore it didn't repromulgate this. There's no evidence at all as to why it didn't repromulgate it. It was said that it may have been a mistake on the part of the minister, but there's no evidence of that.
I mean, what's the position under, this is presumably governed by Pakistan law, this is, what's the position in Pakistan law? Would it be possible to take judicial review proceedings in relation to any failure to, on the part of the government to comply with any of the obligations under this document?
Well, my understanding was that we proceeded on the basis that there was really, in the light of the findings, there was Pakistan law evidence, but in the end, in the light of the findings, there was Pakistan witnesses were called, but in the end, the issue, the government, the lawyer called by the Pakistan government made it quite clear, and I can find in the adjournment the evidence, that once there ceases to be promulgation, that is the end of it, and it goes up, and the judge asked several times, it goes up in a puff of smoke.
There's nothing about promulgation in this document, or is there?
No, but it's...
what is promulgation?
I think it's rather like laying it before the House of Commons.
Laying what before?
The ordinance, effectively, for re-promulgating, for bringing it to life again, because it's not done. It wasn't done.
I mean, suppose, for example, the government had done nothing to establish the trust under paragraph 3.
Yes.
Would it have been open to an interested party such as your client to apply for mandamus, say?
But we mightn't even know. I mean, this is...
Well, that's a different point,
Yes.
whether you might know. I just wanted to know what the legal structure
I can't
is.
tell you the answer of that offhand. Perhaps I can come back. I don't want to second-guess the position in Pakistan, but my understanding is that once the government doesn't re-promulgate, that is it.
Well, it's all regulated actually in Section 89 of the Constitution, which you'll find in Authorities Bundle 1, tab 17. It says that ordinances have to be put before the National Assembly, and if they aren't, they stand repealed after 4 months.
So I think it was pretty clearly understood that was
so
the
it
case.
stands repealed, and that has the effect that the trust just disappears. One can't help feeling that there must be some room for further Pakistani law upon about the consequences if, for example, as I suggested, there were assets. But anyway, we don't know about any of that.
There was some evidence of some rather difficult sort of actions that could be brought. But, my Lord, one has to remember that any actions that would be brought would be in the home court, in the Pakistan courts, by my clients. And here is a government who has decided not to promulgate and made a decision not to re-promulgate. And under the Constitution, that's the end of it.
I thought that the Pakistan courts couldn't necessarily be acquainted with the government,
No,
but it's not our business to get into that.
No, but I'm not saying that, but I'm saying the difficulty for my clients, because my clients have from the outset been of the view that this is a commercial contract where any disputes would be resolved by arbitration.
Which provision is the full one?
Well, anyway, we've got
page
98.
We've got to page 98. You will see at page 9. You will see at page 98. Yes, the 14th of February. Now, it said that the MOU lapsed by its terms. My Lord, nothing may in the end turn on this, but one has to just make these comments. It is, of course, governed by Saudi law, and there's no evidence before you as to the effect of Clause 3. Secondly, the lease and financing plan were sent the following month. Dallah purchased the land and acquired it on the 18th of November, i.e. after the expiry, according to Clause 3. Dallah sent the drawings and specifications, which were only due after the approval date, and these were approved, and they were also approved, according to the evidence of Mr. Naqvi, on the 30th of July. So, and when one looks also at some of the correspondence, it's quite clear that the parties were still negotiating. And so, whether it in practice lapsed, or whether or not the parties continued to work under it, may in a sense be academic. The fact is, for the next few months, the parties were negotiating the financial structure and the financial deal, and the agreement therefore implemented the MOU consistently with the framework, but obviously with some changes. Now,
Can you just give us the reference? What you're saying is that, contrary to Clause 4, it wasn't treated as lapsed, but drawings were submitted and
yes, I
approved.
can give you all those references, my Lord. I was trying to shorten it, but...
no, but I mean, if you want to make good the point, I think I need the references.
Certainly. The drawings were sent and the specifications were due after the approval date. That's pages 73 to 76. They were approved subject to some queries about the toilets, I think. And they were also approved at a meeting with the Prime Minister on the 16th of July and the 30th of July. That's Mr. Naqvi, paragraph 22. Dallah purchased the land. Well, you saw that, but it's also in Mr. Naqvi's witness statement at paragraph, sorry, I thought I had a note of that.
16.
16, yes, I'm great.
They bought more land than
They bought more land, yes.
permitted, so they weren't performing in that sense.
And the minister went over to Jeddah and was offered a meeting, although I believe it didn't take place, only a couple of weeks before the expiry of the 3-month period, and that's page 78. And just to give you an example of the ongoing discussions, without going into the details of the project, if you go to page 102,
102 of...
the bundle C,
Yeah, thank you.
This is a letter from Shezi Naqvi to the Secretary, Ministry of Religious Affairs. This is after the trust has come into existence. And it says, further to our various discussions, I'm pleased to set forth below the implementation schedule covering the provision of pilgrim housing in Mecca. And then there are proposals set forward. And if you go over the page, payment plans, we are proposing two options by which the government could take these buildings from us. And the following agreed assumptions have been utilised in order to develop the payment plan. And the first plan, number 3, a down payment of $100 million from the government of Pakistan has been assumed. Dallah will arrange for the loan. So in the first option, the government itself is putting forward the money against a loan. Then there's Plan A, advance rent. Plan B, partial full lease, 12,000 pilgrims will be free for the government of Pakistan, and the government of Pakistan will pay us $395 per pilgrim. And then legal issues. In order to comply with the legal requirements of the various entities involved, the structure will be as follows. The government to set up the trust. Trust will borrow from Al Baraka. Trust will make the down payment. Trust will enter into the lease. In order to provide the government maximum flexibility, we would propose that the government retain the following two options. The government has the right for a period of 5 years to develop housing on the remaining land, and the government has a right to buy the lease outright during the first 10 years at a price of 345 million, minus the rent already paid. So you will see then it is clearly the negotiation is with the government. The structure will involve the trust. And one sees that again at page 115, moving along in the year. It's not a very easily legible document, I'm afraid. Addressed the Secretary of Ministry of Religious Affairs. It's from Mohammed Jamel, Section Officer, and it refers to a letter, a copy of which was also handed over by you to Mr. Noel, Joint Secretary, Finance Division. Examination of the proposal. We need the following information: feasibility of the project on NPV and payback method, as was due earlier. 2 options plan, A and B, for acquiring the buildings by the government are not clear. It's therefore requested to kindly furnish the feasibility of the project of NPV and payback method, along with full explanation options as mentioned 2 above, to Finance Division on top priority basis. So both parties are clearly talking at that stage about the government.
Well, this is long before the Memorandum of Understanding, isn't it?
This is after the Memorandum of Understanding, but before the agreement.
I thought this seems to be dated the 4th of April.
This is this is a typo. This should be 1996. I'm sorry, my lord, I should have mentioned that.
Oh.
This is 1996. Because it doesn't make sense. It refers to the previous documents.
Oh, yes, actually, yes, you're quite right.
No, your lordship's quite right. It's my fault. I should have drawn your attention to that. We now move to the agreement itself, which is before I move to the agreement, I should just take you to one document which predates, 2 documents which one document predates it, 170. I'm being selective in the documents because I don't want to trouble you with too many. July the 30th. This is about 6 weeks before the agreement. Appointment of managing trustee and construction of Makkah housing project. Government of Pakistan, Minister of Religious Affairs. I'm directed to state that proposals submitted to you on behalf of Dallah regarding selection of trustee bank and development of Mecca housing project were considered and the following decisions were taken. Trustee bank. It's been decided to appoint Al Baraka Islamic Investment Bank as the trustee bank. and permit the bank to use its subsidiary Alto Fique to carry out functions of the trustee bank on its behalf. MACA housing project, the Plan B given in your letter of the 29th of February, which we saw, is accepted, subject to the following conditions and modification. The trustee bank will mobilise savings both in rupee and dollar. The saving mobilised abroad will be utilised towards payment of a $245 million, while the saving mobilised in Pakistan will not be transferred outside Pakistan except for payment of expenses of Hajj when they are actually proceeding to perform Hajj. And then it deals with the position where it's not possible to defray the cost of construction from the dollar savings. And then 2, land as well as buildings are leased out to, and at this stage it's still Government of Pakistan / Hajj Trust for 99 years. Over the page, construction plan already submitted, and this becomes relevant, with the proposal furnished in 1995, will be adopted, so that the plans previously submitted will be adopted on the basis of land measuring 22,000 square metres with construction area of 336,000 square metres. And then 5, proposal regarding arrangement of a 100 million foreign currency loan at interest margin of 2.5% per year and 12 months LIBOR, or fixed interest of 8.75% per year, whichever is less, is agreed. The interest will be paid annually, while the principal will be paid 36 months after each disbursement date. This guarantee will be invoked only if the trust and or trustee bank provides rupee cover for the repayment of the loan. In case the project is not completed, the loan will be transferred to the Dallah real estate. Further clarified that the loan of 100 million will be raised by Dallah Group on the guarantee of the trust, which will be counter-guaranteed by the Government of Pakistan. Further action be taken in the light of the above decisions and in accordance with the provisions of the trust.
And Mr. Akhtar, how many hats did he have?
Mr. Akhtar, I'm off the top of my head. He wasn't he was a joint secretary of the Ministry of Religious Affairs. He wasn't the secretary. The secretary at this stage was a Mr. Kidawi.
So he was a government man, not a trust man?
I believe he was. I don't want to make a false point. I believe he was. Can I double check that and come back to you?
Is there any guidance in Mr. Naqvi's witness statement like this?
Well, I think we can find the answer to it rather than waste your lordship's time. I don't think under the ordinance he was a specified party, because it's the Secretary, Ministry of Finance, Secretary, Religious Affairs Division. And it was Mr. Kidawi who was the individual, I believe, who was involved. But can I double check, and we'll make a note to come back on that point. Let me turn you to the agreement at page 191.
191.
My Lord, and this is obviously, we are now getting to the kernel of the case.
Just file them, just in passing, it's paragraph 38 of the witness statement, but he doesn't actually mention him by name, he just identifies the individual
yes.
as the joint secretary.
It may be that we can ascertain the answer
Yes.
for you, and we will if we can.
191.
191. Now, my Lord, obviously this is an important piece of evidence, and it is right that the government was not a signatory or a party. But as I said at the outset, we wouldn't be here if they were. But under French law, and under other laws as well, it is not necessarily conclusive. But we must obviously...
But it's presumably a significant factor.
My Lord, of course it's a
Because one might have thought that if Dallah really wanted to contract with the government of Pakistan, they would have sent them a draft contract with the government of Pakistan as a party.
Well, my Lord, of course it is a factor, and it's an important factor. I don't go behind that. But when you're looking at we are looking at it from the perspective of French law, looking at the common intention, and one is allowed to look at the whole picture.
I quite understand that.
My Lord, I wouldn't obviously say that it wasn't important. As I said, that is the reason we are here, because otherwise there would be no issue. Now, the introduction is made the 10th of September, and it refers to the trust established, as you will have seen earlier, under Section 3 of the Ordinance, with its registered offices at Islamabad and Dallah, my clients. And the introduction says the trust is interested in leasing reliable housing facilities, and whereas Dallah owns adequate and appropriate real estate. And the Clause 1 is the obligation of Dallah to develop and construct the necessary accommodation. Clause 2 is important. The total lease value of the land area of 22,000 square metres and the total construction cost of the housing, it is computed at respectively 210 million and 135 million, aggregating $345 million, out of which the trust shall pay a lump sum of $100 million to Dallah by way of advance lease payment within 30 days from the date of the execution of this agreement by the parties, subject to Dallah arranging through one of its affiliates a US $100 million financing facility for the trust against a guarantee of the government of Pakistan. Dallah submitting it to the trust a performance bond, and then a counter-guarantee issued by the trust and Al Baraka Investment appointed by the Board of Trustees in favour of the government of Pakistan. So in order for this to get off the ground, the trust has no money. It borrows the money from Dallah. But before Dallah is prepared to lend the money, it has to have a guarantee from the government.
I think, on a quick glance through, this is the only reference to the government of Pakistan in this document.
I think that's right, my Lord, yes.
As a guarantor.
Yes.
And that's consistent with the letter we just looked at. The letter we were looking at a moment ago
Yes.
contemplated that very thing, namely that the role of the government would be as guarantor.
Yes, but what one also has to look at, with respect, my Lord, is the basis upon which this evolved as a financing structure. And underlying it, the underlying project was a government project. But we'll see that more in a moment. Just to take you through this, the government will come into effect on the date that Dallah receives from the trust the advance lease payment and submits the performance bond. Dallah shall develop, construct and complete the housing in accordance with such detailed specifications and drawings that shall be approved by the trust within 90 days from the date of execution of this agreement. There appears to be no obligation to resubmit the specifications, but just a provision for the trust to approve them.
Can I just understand, the guarantee which we were looking at a moment ago is going to be given by the government of Pakistan, not to Dallah, but to whoever is supplying the $100 million, the bank presumably is supplying the $100 million to Dallah. In other words, it's a guarantee in favour of a third party.
Well, yes, indeed. Dallah will arrange...
Yes, Dallah's going to find someone who will lend the money, but I don't know why. I mean, Dallah is supposed to be very big, but nonetheless, a guarantee of the government of Pakistan is going to enable Dallah to borrow more easily, or arrange to borrow more easily.
Also, one has to remember that the loan is being lent to an empty shell, the trust. It has no money. So that there must be some way to recover that money if the trust, for example, if the trust doesn't earn any money from its pilgrims. The moment the trust has got no money...
I see. So it is that way. It is a guarantee to Dallah, then, is it? Dallah arranging through one of its affiliates a dollar financing facility for the trust. Yes, I see. So this, yes.
Is there a draft?
Yes, there is.
Yes, so I'm wrong. This is something which Dallah is going to arrange for the trust. The trust is going to borrow from a third party, or from one of Dallah's affiliates, actually. That's right. And the government is going to guarantee it. Now, what about the second reference to the government of Pakistan at the end of clause 2, this counter guarantee?
Well, that really didn't come into play.
How does it work?
Well, the counter guarantee
Issued by the Trust and Al Baraka Islamic Bank, appointed by the Board of Trustees in favour of the government of Pakistan.
Well, this would be, as I understand it, that if one got that far, what happened, of course, here is that the money wasn't raised, is that there would be
Yes, I see.
a counter guarantee back to the government. But the government was the trigger, because you couldn't raise the finance until the government had produced the guarantee, and you couldn't get the advance payment because the trust didn't have any money until there were facilities available to the trust. So the starting point of anything had to be the guarantee.
Yes, I see.
It's another indication of the separateness of the trust.
Well, my lord, I'm not denying that on the face of this agreement, I couldn't deny on the face of this agreement, that the trust is the party. But what we have argued, and what the tribunal concluded, was that you have to look at who was the government a party to this agreement, either as the only party or as an extra party. One is looking, therefore, outside the wording of the agreement in order to determine that. My lord, I accept, apart from the guarantee, there is no reference to the government. But one has to look at it under French law, not as one would look at it perhaps under English law, just construing it, but one looks at it not only what happened before, but what happened afterwards, something which perhaps is difficult for us to understand, but that's how it's done under French law.
But applying French law, if you look at it at the moment the parties signed this agreement, it's very difficult to see how one could hold that the government was intended to be a party. Every indication is that it wasn't intended to be a party. It was intended only to be a guarantor.
But
both parties, whether you're looking at it under French or anybody else's law.
But fortunately for me, French law doesn't stop there.
That may be so, but I'm just focusing on where we've got to so far in the
You've got to go to the very end, you say. So
you've got to go to the end, yes.
But just in passing, when we were looking at the ordinance,
yes,
it's worth just bearing in mind that clause 10 provided for a fund
yes,
of the trust to be set up, and the sources from which the fund was financed were not government sources, I think I'm right in saying. They were contributions from philanthropists and so on, gains from investments and income from the properties of the trust.
Yes.
So it would be, the idea was a self-financing trust supported by outside interests and so on.
Yes.
So the idea would stand on its own feet, really.
Well, that was the structure, because as I showed you earlier on, there were various structures that were considered. It was part of the Islamic financing. And that was the structure which the government had agreed as the means of achieving the objective of providing housing for the pilgrims. Now, my lord, as I said, I accept entirely that, and I must deal with it, even though it is perhaps not in my favour. It's only right that I should take you through this.
Yes.
So I was just at 4. The Dallah shall develop, construct, and complete the housing in accordance with the detailed specifications. Just one point to note, because it becomes relevant later, is that there's no obligation, as I said, to send the specifications at this stage, simply that they need to be approved by the trust. 5A, the trust irrevocably and unconditionally agreed to take on the lease for a term of 99 years. Then 5C, agreed between the parties upon the execution of the lease agreement, the advance lease payment should be apportioned as payment for the entire period of the lease in respect of such portion the lease premises provides accommodation for 12,000 pilgrims. And then there's a provision, which perhaps I can just summarise, whereby you can pay less by paying earlier rather than to wait for the whole of the 99-year period to elapse. And then other clauses I need take you to, I can jump, because I think the rest is just dealing with the mechanics. Page 198, 19, the agreement should be binding upon and shall inure to the benefit of the parties hereto and to the benefit of their successors and permitted assigns to the extent that such annulment does not violate any specific provision of the lease agreement and applicable law. And it's signed over the page. In the case of the trust, the managing trustee, actually, no, I think the signature is later.
The signature's on page 201, don't we?
I'm sorry?
Signature's on page 201.
Yeah, I haven't got to that yet. 23 is the clause we're concerned about. Any dispute or difference of any kind whatsoever between the trust and Dallah arising out of or in connection with this agreement shall be settled by arbitration held under the ICC rules by 3 arbitrators in Paris, by 3 arbitrators appointed under such rules. And then you have an immunity clause, waiver of immunity, and you will see that the last 2 sentences appear to be in this one. It's the same as the last clause, but added after whether or not claimed, the trust hereby irrevocably agrees not to claim and hereby irrevocably waives such immunity to the fullest extent permitted by the laws of such jurisdiction. 25, the trust waives any objection now or hereafter to citing of the venue of the arbitration. 26 deals with enforcement. 27, the trust may assign or transfer rights and obligations under this agreement to the government of Pakistan without the prior consent in writing of Dallah. And then over the page, you have Mr. Kidawi, the managing trustee of the trust, and also at this time, Secretary of Mora, who signs on behalf of the trust.
Now, your case is what? That the government agreed to all the obligations, to discharge all the obligations of the trust, is it? Or not? It's one thing to say they're a party, but I mean, what do you say? I do say that the agreement was that they were under an obligation to discharge all the obligations which the document itself imposes on the trust, or something less, or what?
Well, it will depend, obviously, on when you would determine they became a party. If they're a party throughout, then they would have obligations to ensure, vis-à-vis my clients, that my clients were paid in accordance with the terms of the contract.
I mean, what about the waiver of sovereign immunity in clause 25? Is that a waiver by the government on your analysis?
Well, my lord, if the government...
And if not, why not?
Well, my lord, in one sense, if they're a party to the agreement and a part of the arbitration clause, it doesn't matter. They did waive, of course, sovereign immunity under
No, but I'm asking whether, on your case, the government waived any state immunity it might have under clause 25.
Well, my lord, it's right that it doesn't say so specifically in that contract.
No, but it doesn't say it specifically about... doesn't impose any obligations on the government specifically.
Yes, but, my lord, it may not matter. It
may not matter, but I'd just like to know, on your analysis, whether that is a waiver by the government.
Well, my lord, I think on my analysis I would have to say that the government didn't specifically, in terms, say so. I couldn't argue that. The consequence would be, if they were a party, would depend on how one interpreted the contract vis-à-vis the government.
Right.
And if the conclusion is that they were a party throughout, even though they hadn't specifically said so, if they were a party by virtue of being a party to the arbitration clause, that would be sufficient for my purposes.
Well, that isn't right, is it? Your original case before the tribunal, or Dallah's original case, was alter ego or successor.
Yes.
In those circumstances, they would simply be the same
Indeed.
as the trust.
Yes.
But if they're simply an additional party, in some sense, then the immunity provisions wouldn't necessarily apply.
That, with respect, was what I was perhaps trying to say, but the immunity provision itself, as stated, set out, but that wouldn't necessarily matter, because if I'm right under French law that they are a party, then if they're a party to the arbitration agreement, in any event, the immunity goes vis-à-vis the agreement by virtue of Section 9 of the State Immunity Act.
There is actually a difference, because the immunity clause is wider, isn't it? It's waiver of execution and attachment.
Yes.
Yes.
Clause 27 does seem to envisage the government as a separate party. The whole idea of assigning and transferring rights and obligations is that they were separate.
Well,
what would happen to Clause 26? Would that carry with it if rights and obligations were transferred under the agreement?
Well, my Lord, I think it's right that, again, specifically, one couldn't impose obligations which specifically relate to the trust in relation to sovereignty or
why then any other obligation of the trust?
Well, because vis-à-vis my clients, it's sufficient.
Well, that's a different point. What we're trying to work out is what the agreement actually was.
Well,
I mean, if your case is based on succession,
yes,
as my Lord Collins suggested it was at one time, that's one thing. But otherwise, are we to read the document as if it read the trust and jointly and severally the government, or what?
well,
It is a bit of a difficult issue.
well, my Lord, there are alternative ways of putting it. One could read it as the trust and the government. One could read it as the government effectively being the party rather than the trust. And of course, there is the third alternative, which is what I'm going to move to now, is that the government, even if they weren't by a common intention a party earlier on, they did by their subsequent behaviour. Okay. And that may be the explanation.
What's your case then on this?
Well, my case, my Lord, the way the tribunal dealt with it, for my purposes, I can argue it in a sense both ways. I can say that the underlying project was always a project with the government. And when you look at the tribunal's award, that in itself would not necessarily have persuaded them to conclude that they were a party. What you have to look at, and what is crucial, which is what we're coming to earlier, so to an extent this is background, but because the agreement in itself does not specifically make them a party, but you have to look at the whole picture. And looking at the whole picture, together with the fact that at the end they step back in for the purposes of French law, my Lord, one is therefore allowed to look at it in the round, or alternatively, one can look at it at a later moment and say, well, OK, it was the government project, but perhaps earlier on, because of the agreement, they were not a party. But it's quite clear from their subsequent behaviour, and looking at the overall common intention, taking account of what happened earlier, that, albeit for the short period they weren't a party during the existence of the agreement, nonetheless they were an underlying party to the agreement.
Did the tribunal make a finding about whether the government were a party to this agreement? I'm not sure that they did.
Not sure
I think they.
I'm going to come to that in a moment. What I was proposing to do, with your indulgence, was to finish the facts and then take you to the award and Mr. Justice Aiken's decision, rather than jumping from one to another. But I can obviously alter the way I was going to do it if it would assist you.
So where have we gone?
Well, I was moving from the agreement now to what happened afterwards. Given that the agreement only had a limited life, there was limited scope for performance. But there are three documents which are relevant. One in particular, and if I could take you to those three documents before I come to the crucial factors. The first letter was a letter at page 234. And this was from the Minister of Religious Affairs and dealing with the finalisation of the proposed schemes, which is the schemes for the taking of money. Again, albeit that the trustee bank had been already appointed and had been appointed by the trust, we still have the Minister of Religious Affairs writing, not perhaps the most significant letter. The next letter is a letter of the 4th of November, which is at page 309.
309?
309. Similarly, dealing with the schemes, the implementation of the scheme. But the more critical letter, and may give an explanation as to what happens subsequently, is the letter at page 300, or the facts at page 314, from Shezi Naqvi to the Minister of Finance, Government of Pakistan, attention Javed Noel, Joint Secretary. Despite our repeated reminders, we have not received clearance of the documents from the Ministry of Religious Affairs, who claim that the documents are pending clearance by the Ministry of Finance. Now, the documents referred to, if you go back, are loan documentation, which, pursuant to the agreement, Dallah sent to the government. These are not the exact documents, but they are stated to be typical of the sort of documents which would have been sent. And you see that at page 238, if you just hold your hand in 314, 4 sets of documents. And interestingly, there are just a couple of points to be made on those documents. Under the heading Representations, which you see at page 256, if you go to 1121, one of the representations is the borrower is under the control of the government of Pakistan. This is for the purpose of the loan. And then if you go
Which
to
one clause was that?
clause 1121, page 258.
And this is of what?
This is the loan documentation, which was sent, or it's an example of the type of loan documentation which would have been sent to the government following the agreement, because the agreement, as you will recall, it was necessary to provide the financing. And so please find attached 4 sets of documents of preliminary draft for the term loan.
What's the significance of someone being under control of the government of Pakistan?
Well, it simply shows the close relationship between the two. And the fact is also, at 261, an event of default, the borrower ceases to be under the control of the government of Pakistan. Pakistan ceased to be a member of Good Standing International Monetary Fund. That's really the only point that I make from that. But that was sent, and therefore, to put that in context at page 314, you'll see that Shezi Naqvi is waiting for clearance of the documents from the government. We're now on the 21st of November. As you're aware, we signed the agreement on the 10th of September, and you were required to conclude the financing within 30 days. However, as a result of your clear market mandate to ANZ Grindlays, we were forced to delay and only released our documents on the 22nd of October 1996, the date the ANZ mandate expired. That was an issue on the liability, which perhaps we can park for the moment. I'm sure you realise it's becoming more and more difficult to keep the syndicate together, and we would therefore request you to expedite the latter. So you will see that there is being chased not only the Minister of Religious Affairs, but also the Minister of Finance to get on and sort out the documentation. And this may be the background to why the government felt something had to be done to resolve the position. On midnight, as you know, on the 11th, 12th of December, the trust disappeared.
When was the change of government?
6th of November, 1996.
Yes.
And as has been said, in its short life, the Trust never acquired any funds, it never made any rules, it didn't have its own note paper. All correspondence from Dallah was with members of the government, sometimes wearing dual hats, sometimes not. There's no evidence of any document during the life of the Trust signed by any individual stated to be in a representative capacity.
But it's not said that they're the alter ego of the government.
No. Other than the agreement itself. So it was an empty shell, really, which survived for 3 months after the agreement was signed. Now, one has to look at the consequence and the effect of the failure to re-promulgate the ordinance.
It's a matter of interest. I mean, don't spend any time on it, but the 19 million loss related to what?
It was the financing charges in relation to the project.
What, having bought the land?
Having bought the land, there was financing charges.
But you bought the land before this agreement was signed?
But in reliance on the MOU, or in part of the land, in any event, yes.
There's never been any proceedings or attempted proceedings on the MOU?
No. And in any event, the MOU also had an arbitration clause.
Yes. Saudi Arabia, yeah.
Saudi Arabia. So,
Would there be any reason why these claims shouldn't have been made under the MOU?
well, probably by the time the agreement came, the agreement would have implemented, unless the agreement itself didn't exist, the agreement would have either implemented according to Saudi law or replaced according to other law. But it certainly refined the MOU. I think, with respect, it might be difficult for us to have brought... in any event, proceedings were brought on the assumption that the government were a party to the subsequent agreement. It would have been difficult to bring proceeding or arbitration proceedings under the MOU.
Was there enough in the MOU actually to bring proceedings on?
Well, I think that's part of the problem. It wasn't sufficiently
quite a lot was left for subsequent decision and negotiation, wasn't it?
I think that's right.
I suppose that would depend on Saudi Arabian law.
It was a framework document, and clearly what happened, because there must have been a discussion as to whether it should be Saudi law or Pakistan law. In the end, it was no law.
There might be a problem that the land was larger than the permitted limit under the MOU.
Well, with respect, no. I mean, the fact that if you buy your own, if you're even in an ordinary situation, if you enter into a development contract and you're asked to buy land, the fact that you buy more land for your own benefit, with respect, unless the sole purpose was for your own benefit, but if the dominant purpose or the real purpose of you buying it was to fulfil a contract, we would submit that shouldn't make any difference. So let us move now to what is perhaps the more critical area of the factual.
There was one other document we were going to look at where that was subsequent to this 21st November, or we covered all the...
We're coming to the critical letter.
Yes, right.
But before I do that, if I may, I would just like to look at the effect with you of the failure to re-promulgate and what really happened. Because the background is that my clients entered into a long-term project, 99-year lease. There was the structure that we've seen. The agreement describes the trust as having been established under Section 3 of the Ordinance, specifically. And its continued life was clearly dependent upon the government re-promulgating the Ordinance every 4 months for 99 years. The trust could not perpetuate itself. Its life was dependent upon the government doing it. And so a positive decision in our submission was clearly taken not to re-promulgate it, so that it lapsed on the 11th or 12th of December, only 3 months after the agreement had been signed. Now, it was argued that, well, this may have been a mistake and the government didn't know what it's doing. There's two answers to that with respect. First of all, this is a government. And quite frankly, one would assume that the government knew what it was doing. Secondly, if it was a mistake, there is evidence referred to in my learned friend's own skeleton that you can repromulgate retrospectively. So that if they forgot, they could do it subsequently, but there was never any indication that it was their intention to repromulgate it. It was clearly the government's intention, for whatever reason, and we would submit that it's likely to have been that the change of government decided that it was not appropriate to continue with this project, something it was perfectly entitled to do, but it should have done so by compensating my clients. Having decided this, they then decided not to repromulgate the ordinance. And this emphasises the control of the government. In that the government was in effect the entity responsible for terminating the agreement as between the Trust and Dallah. And under French law, as I said at the outset, involvement and behaviour of all parties during the negotiation, the performance, and, if applicable,
perhaps
the
they were
termination...
inducing a breach of contract.
Well,
I mean, perhaps your true cause of action is an action against the government by taking steps to eradicate or eliminate the trust, thus preventing the trust from carrying out its obligations under the contract. And tenor under English law, it would be a classic example of inducing a breach of contract.
Well, indeed, my lord, but as I say, we are looking here at the French law, and the French law is different. And this is one of the problems which I'll come to when we're looking at the review, is that we are all here, however hard we try to put ourselves into the position of a French judge, inevitably there is the English bias as to how one looks at it. And what one has to try very hard is to look at it here from the perspective...
Well, perhaps you'll be able to enforce the award in France.
Well, I'll come to that in a moment.
But your case wasn't that different from inducement of breach of contract because, as I've understood it, the arbitral tribunal decided that the government was not the same as the trust, but was nevertheless a party. And then it was held liable in the interim award for... The government was held liable for repudiating the contract,
yes,
without it being said inside that it was subject to the obligations of the trust. So that's not very, very far from inducement.
Well, it wasn't on that basis. The basis upon which it was held liable was clause 2, in that, there are various grounds, but effectively preventing my clients from raising the funds in order to make the agreement effective, because of one of the reasons was the failure to provide a clear market mandate. So actually the liability went to the initial stages of the failure to provide the finance and to enable my clients to get the project off the ground.
But the principal holding in the second partial award was of repudiation, wasn't it?
Yes, indeed. But the repudiation effectively at the beginning in the context of the financial aspect of it. I never got further down the line to constructional matters of that sort.
But I think the way the tribunal put it, and I'm looking at page 34 of tab E in the appendix, is that it was a political decision of the government to set the trust up in the first place for specific... It's page 34, paragraph 12.1-1.
Yes.
And it's the first full paragraph on the page. It was a political decision of the defendant for specific activities which the defendant wanted to perform, and was cancelled also by a political decision of the defendant. That's the sort of point you've been making,
yes,
really. And the conclusion they draw from all of that is that it was an alter ego, the real party in interest, therefore the proper party to the agreement. Well, that's their conclusion, I think.
Well, I'm going to come to other parts of it as well, because they do refer to it being an act of sovereignty, an act of political will in a different context. But I was going to, if I may, take you through, it's only about 3 pages, when you've seen this, to compare the two reasonings, rather than jump on selected paragraphs, because I think it may be easier for you if I complete this analysis and then take you to the two documents. So the reality is that the removal of the trust as a contractual party was the act of the government. and it must have known the consequences. And it's agreed for the purposes of this appeal that upon the lapse the trust ceased to exist. The government is not a successor to the trust, didn't become bound by the rights and obligations of the trust under either the agreement or the arbitration agreement, by way of operation of law, and there was no transfer of the agreement or arbitration agreement to the GOP on the trust demise. So far as my client's concerned, as at 1 minute past midnight on the 12th of December, we were left without a named contracting party, without a right of recourse against anybody, and yet had expended considerable time and resources on the contrary.
Well, when did it dawn on your clients that that was the case?
Oh, later down. I mean, we weren't aware of this at the time. Because what happened, we were chasing, and you will see in a moment, 6 weeks later, the letter arrives, which is the letter of the 19th of January 1997, which is the one which both the tribunal and the English court really was the critical letter to the conclusion in this case. But one just has to put it into perspective, because the position was, once the trust had ceased to be a contracting party, there was no contracting party who could write a letter. The only contracting party that could write a letter, if it was a contracting party, either before or subsequently, was the government. The trust was dead on any view. Mr. Lutfullah Mufti, who wore two hats originally as Secretary of the Trust and Secretary of the Minister of Religious Affairs, had come back into the government in December. But he could no longer be Minister or Secretary of the Trust because there wasn't a trust.
He may have thought he was, though. He may not have realised that.
But, my lord, there's no evidence to that effect.
Well, we'll look at the documents, but on the face of it, if people write in the name of a trust, they presumably think the trust exists.
But he didn't. He wrote, we'll see the letter, he wrote Secretary. He didn't write, as he could have done. My lord, your point with the greatest respect would hold good if he wrote Mr. Lutfullah Mufti, Secretary of the Board of Trust, but he didn't. That's the point. And he wrote on government.
Well, I was referring as much to the complex of documents, including the 20th of January proceedings, as just to the letter.
But so the way to look at this is when one comes to the position as at the end of December, beginning of January 1997, there is no trust. With the greatest respect, the government must know whether know or be presumed to know what its law is, that this ordinance had not been re-promulgated. The very least one would have assumed it would have been checked before a letter was written. There is no evidence of any correspondence. There may have been, but we haven't got it, after the letter of November 1996, until this letter some 2 months later. And then, out of the blue, comes the letter of the 19th of January, which you will see at page 315. And this played a pivotal role in the determination of the tribunal and the court. Effectively, one could say that the earlier material was possibly equivocal in both the tribunal's and the judge's views, but the critical position was this letter, and read obviously in the light of what happened by way of a failure to re-promulgate. And I must deal with
there wasn't any oral evidence about any of this, was there?
None at all. And of course,
Mr. Lutfullah Mufti didn't come along to explain who he meant by us in the last line.
No. And of course, the onus is on the government of Pakistan to prove that this, one of the gateway here being the validity of the agreement. So it's addressed to the chairman of Dallah. It refers to the agreement of the 10th of November. Pursuant to the above-mentioned agreement for the leasing of housing facilities in the holy city of Mecca, you were required within 90 days of the execution of the agreement to get the detailed specifications and drawings approved by the Trust. However, since you have failed to submit the specifications and drawings for the approval of Trust to date, you are in breach of a fundamental term of the agreement, which tantamounts to a repudiation of the whole agreement, which repudiation is hereby accepted. The question is, of course, by whom? But just before we get to that, on the question of the drawings, it may be a small point, but it may be indicative. As I showed you when we were going through the agreement, unlike in the case of the MOU, there was no obligation on my clients to actually submit the specifications and drawings for approval. The approval was to be by the Trust, and these specifications had been approved shortly before by the Prime Minister. So in other words, it wasn't my client's obligation, the onus was on the government. And the wording from this is more akin to the wording of the MOU than the wording of the agreement. Moreover, the effectiveness of the agreement was conditional on your arranging requisite finance facility amounting to $100 million within 30 days of the execution of the agreement. And your failure to do so has prevented the agreement from becoming effective, as there is no such agreement in law. This is without prejudice to the rights and remedies which may be available to us under the law. Now, the letter is written on the government-headed notepaper. I should add, it doesn't appear in this copy, but under Mr. Lutfullah Mufti's signature, the word secretary appears, just secretary.
Well, we have that at page 315.
You've got that, right.
Do we? Yes.
It's not in my copy. It's written on government-headed notepaper.
But the secretary, is that equivocal?
It's equivocal.
The statement secretary.
It doesn't say secretary of either. But if you look at the headed notepaper, one would assume, without there being any indication that it's the secretary on behalf of the Trust, that it's the secretary of the Ministry of Religious Affairs.
Does it have a secretary?
Was he ever the Secretary of the Trust?
Yes. No, he was not the Secretary of the Trust, because he would have been the Secretary of the Trust. I think I'm right in saying the date. He would have been the Secretary of the Trust had the Trust still existed. But because he came back in mid-December and the Trust, I think, had ceased about a week before, in fact, he had never been the Secretary of the Trust, but he clearly wasn't the Secretary of Trust on any view.
Did the ministry have a secretary?
The ministry had a secretary, and it was...
He was both. Paragraph 18 of the statement of
I've just looked at the
facts
statement
at various times, and you say he just wasn't at this time, but the secretary of the ministry was automatically secretary of the Board of Trustees.
That's right. I've just lost my call button.
Paragraph 18.
Yes, if you go to the statement of facts, you will see that we've set out the dates.
MORE, that's the Ministry of...
Religious Affairs.
I see, so secretary could be neither here.
If you go to paragraph... it's paragraph 18 of the agreed statement of facts. And you see... this is what the respondent says. We're not in a position to verify that, but I'm happy for present purposes to accept it as accurate. The position of the Secretary of Mora was held by Mr. Mufti between the 26th of August and the 19th of December. So that was before the agreement, but after the MOU. And between the 23rd of December and the 3rd of June 1998. And in between, it was held by Mr. Kidwai. So in practice, Mr. Lutfullah Mufti was never a secretary of the Trust, because by the time he himself came back in, it had gone.
Yes. Well, the trial judge, Mr. Justice Aikens, in paragraph 117, seems to accept that he was writing in his capacity as secretary to Mora.
He does, yes.
Well, he adds whatever he may have thought at the time.
But, my Lord...
I mean, on the face of it, if you read the first paragraph, the conventional understanding would be that this is the trust alleging a repudiation.
Well, with respect, my lord, one might if the trust existed. The trust didn't exist. And if you knew the trust didn't exist...
Well, that's hence the importance of my lord's point that Mr. Justice Aikins put in brackets whatever he may have thought.
Yes.
Since he never came to tell us what he...
Well, he does go on to actually, and no doubt you're going to take us to this, is what happens afterwards, because he says it's possible to get an indication of the state of the mind of the government, at least, if account is taken of the proceedings that were begun on the following day. And you're going to take us to that, are you?
But it's also relevant, perhaps, before I just do that, in that it's referred to, if I give you a reference, because it's a very short reference, it's bundle E/B/7, paragraph 2.
So, sorry, can you give me that one again?
E/B/7, paragraph 2. We'll come to it when we look at the Pakistan proceedings. But Dallah replied to this letter, but replied to the government, not the trust, on the 26th of January, denying the allegations. We don't have the letter, we only have a summary of it in the pleadings, and asking the government to withdraw them and to proceed with the implementation of the agreement. And the letter continued, if the government failed to do so, it would institute proceedings against it. So looking at the common...
Where have we got this letter?
This is a letter we'll have a look at in a moment. In the
E/B.
We don't have the letter, we have a summary of it in the pleading.
And it was E7.
EB7. I'll show it to you when we come to
Well, I
it.
don't see it, that was me.
Well, maybe I've given you a wrong reference. We'll come to it in a moment, my lord, because we're moving on to the Pakistan proceedings briefly.
Yes.
But the point being, the only point I'm making there is that the reaction of Dallah was to write back to the government and to ask the government to continue with the contract and to deny the repudiation.
And where's the summary of that letter?
The summary of that letter is in bundle E. It's the Pakistan proceedings.
Oh, no, sorry, if it's the same reference you've just
Yeah,
given us, so I come to it in 2 minutes.
Yeah.
Yes.
As of the 19th of January, your clients were still in a state of ignorance as to the non-existence of the trust?
That is my understanding. There's no evidence to the contrary. And when asked rhetorically, and this is what the French law in our submission would say, what would be the purpose of writing this letter if the trust had gone and it was in the only party had intended to be the trust?
Muddled thinking, actually.
Well, my lord, I know with respect your lordship says muddled thinking, but we don't know because there's no evidence. No. And to assume that against my clients, in my submission, when the onus is on the government to establish, on any view, what one says about this letter, is that you have here, it must, even if we're wrong as to its interpretation, it is capable of two interpretations. It's not a black and white situation, this. And that may be important later when we come to the submissions. And it is a very odd letter to write. And whilst one can give the benefit of the doubt to a government, one must remember it is a government, and the government should know whether or not its own legislation is alive, whether the trust exists. And to take the muddled thinking point, here you have, it's not some, with respect, lowly person in the ministry. You have the Minister of the Secretary to the Minister of Religious Affairs, who would normally also be the Secretary to the Trust. One would have thought he's a new person coming into the ministry. He would, even if not himself, would have asked somebody, what is the position? Because why write this letter out of the blue unless there is some reason to do so? And the reason to do so must be, in our submission, that the government had decided, for whatever reason, the new government, that they didn't want to pursue this project. And one would have assumed that they would have made some inquiries.
So it was a sort of affirmation of the contract and a repudiation of it at the same time.
Indeed, and by becoming involved in the termination, both in the context of removing a contracting party, so that if the contract stayed alive, it could only be alive against the government. And effectively coming in at this stage and saying, well, the agreement exists, but because of your action, you've repudiated it, and now we accept that repudiation, so it no longer exists. Under French law, it is our submission that that is sufficient, particularly when you look at the earlier history, but in itself it's sufficient to make the government a party to this agreement. It was as the tribunal said, it was wholly unnecessary to write this letter. Why write, one asked rhetorically, why write this letter unless there was some concern on the part of the government that they themselves were on the hook or were potentially liable for some sort of claim by Dallah?
Well, the judge didn't agree with that, did
Judge
he?
didn't agree with it.
And that's because of what he took from the proceedings and
From
the
what
way
he took from the
they were
proceedings,
framed.
which we'll look at now. My Lord, if one now puts that away and goes to bundle E, give me one moment, my bundle is correct. And perhaps just one point in passing, it's a small point, but of course, as a method of dispute resolution, although it's not an answer, obviously, to the question, but it's quite clear that the government of Pakistan were not averse to arbitration because they agreed to arbitration as a method of dispute resolution in the MOU. Yeah. Just a small point, but perhaps I should just mention it. Now, the Pakistan proceedings, there were three sets of proceedings that are relevant. The first is the 1997 proceedings. You will see, perhaps I should have shown you, but at the top of the letter of the 19th of January, there is a fax date the 20th of January. It looks as if it was faxed on the 20th of January, which is the day that these proceedings were started. So it may or may not be that they were, the letter was part of the preparation for these proceedings. There's no actual evidence before the court as to why they were launched in Pakistan in the name of the defunct trust. The only facts that we know are, one, that I've mentioned, that Mr. Naqvi was chasing members of the government. Two, that the Secretary of Murrah changed after the change of government, and Mr. Lutful Mahdi became its secretary, and you've seen the dates. The proceedings rely on the letter in order to assert an alleged acceptance to an alleged repudiation. And the proceedings sought a declaration that the agreement was repudiated and sought an injunction. So the letter was integral to the ability to bring the proceedings. And again, whilst you can, because there is no evidence, whilst, yes, one way of looking at it is, as the judge said, well, this is the clearest indication as to why the government did what it did. On the other hand, one could take a more cynical view and say that this was a tactic on the part of the government to bring proceedings in order, as boat embraces, to make sure that there would be no proceedings against the new government for something which had been undertaken by a previous administration.
I wonder whether it would be helpful to break at this point. If we're going to be looking at the proceedings, and give us the time, and come back at 2:00.
Indeed, my Lord.
Thank you.